Hello and welcome once again to another packed episode of Your Family Wealth, the show that brings you all things related to wealth protection, wealth planning and wealth transfer. I'm Remy Ayala and I've got plenty lined up for this episode. But before we get started, here's a reminder of the segments for this week's show.
Coming up, the Family Wealth Quiz. Answer at the end of the show. Topic of the week, case history, guest expert, tip of the week.
Right, so what's on today's show? Well, this week we're talking all things wills, one of my favorite subjects. Well, maybe that's because I wrote a book on it. In my topic of the week, I'll be talking about the intricacies of making gifts of properties. So many pitfalls to avoid if you don't want your beneficiaries battling it out in court afterwards. Then my case history involves a widow and her stepson who go head to head in another epic battle of wills. And I have as my guest expert Matthew Moore of Moore Probate Research, who will tell us what happens when an executor can't find a beneficiary. And in my tip of the week, I'll give you a very crucial tip that anyone making a will must not miss. But first, here's the Family Wealth Quiz.
Gifts you make in your lifetime will no longer form part of your estate for inheritance tax after how long? Is it A. 7 years, B. 5 years, C. 4 years? The answer is coming up at the end of the show. Hope you get it right.
Do make sure to wait till the end of the show to find out if you got it right. This week's topic of the week is about gifts of property in your will, and I'm talking about specific gifts of land or property that you own. There are many things for you to consider and watch out for, and I'm going to be telling you all about them. The first thing that you want to think about carefully is what kind of interest you want to give that person. Are you giving them the property outright, or do you want them to have the use of the property for their lifetime or only for a set period of time? Be clear in your mind which kind of gift you want to make. A lot of will battles involve fights over property. Be careful to get it right if you want to avoid that. If you only want a person to have use of the property rather than owning it outright, there are still certain provisions you need to consider. Do you want them to have a right of occupation only? Alternatively, you could give them a right of income from the property. I will explain the distinction between the two. If they have a right to income, they can occupy the property or rent it out. If it's rented out, they'll be entitled to the rental income. The property can also be sold, the money invested, and they will still be able to enjoy the income from that investment. If you only give them a right of occupation, that's all they're entitled to. They can't rent it out and get the rental income, and if they move out, they get nothing. As you can see, they are completely different things, and many people fail to appreciate the difference between the two and end up with provisions in their wills that are not very clear. You need to decide whether you want the person to have the right of occupation or income over the property for the rest of their life, or if you want to limit it to a specific period of time. A lot of unmarried partners prefer to give a right of occupation instead. You may decide that you want to give your partner the right to continue living in the house, but you want that right to end if they marry or cohabit with another person. Alternatively, you might just want them to have a period of time, say a couple of years, to find another property to live in or to make appropriate arrangements for themselves before the property is passed on to your children. This type of provision tends to be used more commonly where there are children from a previous relationship. It will ring-fence the property for them so they get it eventually. If you give a person a right of occupation or a right to income, who's to maintain the house during that time? You should make that absolutely clear. Normally, you would provide that the occupant should maintain the property, pay all the outgoings, keep it in good repair, and put an adequate insurance policy in place. But remember to say so. Another thing about right of occupation is the household effects. If you don't specify that the gift includes the household effects, such as furniture and fittings, then the beneficiary gets the house, but without its contents. It's common to include household effects when you give someone a right of occupation, so that they have the furnished property rather than an empty house. But it's your will, and you can do what you want. The important thing is to make sure that point is covered. And what is to happen when the right of occupation ends? Who does the property go to at that stage? Some people fail to make any provision about that, and the property could end up passing to beneficiaries you hadn't intended it to go to. Make sure you identify the property clearly. For example, if you own numbers 103 and 103A, you should be clear which of the two you're referring to in your will. Again, if you own 3 flats in a building known as Grove House, do refer to all 3 flats or whichever of the 3 flats you want to give away. Are you making a gift of your residence? Be careful. If you say in your will, I give my house to my niece, what happens if you move to a new house? Will that new house go to your niece? Maybe not. What should you do? Well, you should make it clear that the gift is of any property you live in at the date of your death. In one case, a lady left her property to her grandson, but some time before she died, she suffered a stroke and had to move to a house more suited to her needs. The gift to the grandson failed because the house she mentioned in her will was the one she lived in when she made the will. The grandson had to go to court to fight it out with another beneficiary. If you own both the freehold and the leasehold, be clear whether the gift is of the freehold or the leasehold or both. What if you have a mortgage on the property you're giving away in your will? Who should pay off that mortgage? You need to be clear about that. Is it the person you're giving the property to, or is the mortgage to be paid off with money from the rest of your estate? What if you took out an insurance policy linked to the mortgage? Do you want the beneficiary to have the proceeds of that policy so that they can pay off the mortgage? Again, you should make that clear. If you say nothing, the property will be assumed to bear the mortgage liability and so may need to be sold to pay off the mortgage. What if you decided to sell the house and had already exchanged contracts, but before the sale could go through, you passed away? If you have entered into a contract to sell the house, is the beneficiary of your property under your will to get the proceeds of sale? That's yet another thing you should make clear in your will. You can see that gifts of property in wills can be quite complicated. Lack of clarity on these kinds of issues is what leads to beneficiaries ending up in court. You must make things absolutely clear. Otherwise, your beneficiaries may end up slugging it out in court, and I'm sure that's not what you would have wanted to happen. I do hope you now understand all the important provisions you need to think about when making a gift of your property in your will. Next is case history. This case was about the estate of John Payne from East London, who died in 2012 at the age of 74. He had 4 children with his first wife. After leaving her, he married Kim Payne soon afterwards. They had no children. At the center of the case was John Payne Jr., one of John's sons, and John Payne's wife Kim. After John Sr.'s death, John Jr. produced one will and Kim produced another. This led to an epic battle of wills that would run for many years, going all the way up to the Court of Appeal. At stake was an estate worth around £600,000. Not surprisingly, the will produced by John Jr. left the bulk of the estate to him, while that produced by Kim the widow left everything to her. The bad feelings between the two ran deep, and the police had to be involved at one stage, with a restraining order for harassment being issued, and this threatened to spill over into another criminal case. Which will would be upheld? The 2012 will produced by John Jr., which was dated just a few months before his father died, and supposedly witnessed by his girlfriend and her mother. Or the 1998 will produced by Kim and made a few years after her marriage to John Payne. All will be revealed in this week's case history. The link is coming up at the end of the show. Remember to watch the full case, and it's coming up right after the show. The link is at the end. When a person dies, they either die having left a valid will or having left no valid will. Whichever the case, it's the legal duty of the executor or the administrator to ensure that all entitled persons receive their rightful share. But what if those entitled to benefit from the estate can't be found? That's the question for today's guest expert, coming up in just a moment. My guest expert today is Matthew Moore, Research Director at Moore Probate Research. They specialize in locating missing heirs and beneficiaries. Welcome to the show, Matthew. I'm so glad you could join me today.
Thanks, Remy. Thanks for having me.
I know you locate missing heirs and beneficiaries, but what does that really involve?
Well, there's quite a wide range of things we do. I mean, it really runs from just locating one missing legatee, one missing beneficiary named in a will, all the way up to locating maybe 50, sometimes even over 100 heirs on intestacy, so where there's no will. So there's quite a large range of what we do, you know, very small jobs to very large ones. And that also includes locating people overseas.
And what difference does it make whether you have a will or not?
Well, generally speaking, with a will, we're looking for named people, so we know who we're looking for at the beginning. That's not always the case, but generally speaking, that's the case. Whereas with an intestacy where there's no will, we start off not knowing who we're looking for. We first identify the people who are going to benefit, and then we find them.
Who do you typically work for?
Typically, we work for UK solicitors, but we also work for overseas public trustees and also for the general public, so people who are administering an estate without the assistance of a solicitor.
What should people include in their wills to make their beneficiaries more findable in the future?
Obviously the name, but it should be the name plus something else. It's very hard to find someone if it's just the name. So it's usually a name and address, that's standard. In some cases, if you don't know the address, you can include some other information. So a good example would be a godchild who you may have lost touch with. You may not have a remotely recent address, but you probably know the names of their parents. So you could include something else about that godchild, you know, my godson, Nicholas, the son of X and Y. And that will give us something to start with. So it's a name plus some other information.
And how do genealogists charge for their services?
There's really two ways that genealogists charge. The first, and the way we work, is a time and expenses basis. So a budget is agreed at the outset based on the number of hours that we think the case will take, and we simply charge for the time. There's also the contingency approach, whereby the genealogist agrees to fee with the heir when they find them. We don't work on that basis for a number of reasons, mainly because we think it's unfair that a beneficiary would be asked to sign a contract without all the information in front of them.
How much time does it normally take to locate missing beneficiaries and heirs?
Well, I'd say as a rule of thumb, I'd say if we were asked to find one missing legatee with a name and a last known address in the UK, it would take us, in terms of our time, probably somewhere up to 2 hours maybe. And to find heirs on intestacy, it could range from 10 hours to 50 hours. That's in terms of the time we spend. In terms of how long it would take from us starting a case to reporting, for a missing legatee, maybe 1 to 4 weeks. And for an intestacy, it could be 3 weeks to 3 months, but give or take, depending on what happens.
What information do you ask for when you're instructed to start a search?
We always say as much information as you've got, we'd like it. You know, it's much better to have too much rather than not enough. But I mean, I've kind of touched on this already, but for someone named in a will, the name and the last known address would be a great start, or the name is something else. For an intestacy, we can really work with almost nothing, you know, a name and a date of birth and nothing else, or even a name and a date of death and nothing else. But the more you can give us, the better. The more you give us, the less we have to find out, and obviously the less time we'll spend.
And if you search and can't find a beneficiary, how can the personal representative be protected?
There's several different things you can do if a beneficiary can't be found. I would stress that most beneficiaries can be found, but if they can't be found and you've taken sufficient steps, then you can sometimes get a policy, an insurance policy, which covers you should that person turn up. That's not always possible. For example, a missing son of the deceased is probably not insurable because he could turn up at any time. So there are other options. You can make payments into court in some cases. Sometimes you could find a charity that would take it, on the proviso that if the person turned up, they'd pay the money back. So there are various options to protect yourself.
What kinds of search can you help with?
Well, we always say that we can really look for anyone as long as it's either to their benefit or it's for a mutual purpose. So we don't trace debtors, but we can trace missing freeholders. Sometimes you might have a situation where a couple have split up and become estranged, but they still own the property together. So we can trace a missing spouse or partner. We can also get documents. We quite often have to get documents to enable the administrator or the executor to transfer a nil rate band from one spouse to another. So there's a wide range of things we can do.
Do you have any additional advice for personal representatives when dealing with an estate?
Personal representatives, executors, etc., don't necessarily realise the kind of responsibility that they're in and the potential personal liability if things go wrong. So I would say be very certain that you know how to distribute an estate before you do it, particularly on an intestacy. I've seen mistakes over the years, and you really don't want to be trying to claw money back from people who've received too much. So that's the first thing. And the other thing is, if it's an intestacy, you really need to be certain there isn't a will. And there is a thing called a will search which you can do, which will protect you in case a will turns up in the future. It's all about protecting yourself because you are in a position where if something goes wrong, you could be personally liable.
Thank you very much, Matthew, for joining me today. The service that your firm offers is definitely a lifesaver to those who find themselves in the difficult role of executor or administrator of an estate.
Thanks, Remy. Thanks a lot. Pleasure.
Details of how to contact More Private Research will be coming up shortly. But first, are you dealing with an estate where there's no will and you're not sure who's entitled? Or do you want to know what happens if you pass away without a will? You can download an intestacy guide that gives you all that information. It's available from my website, remyayala.com/intestacy guide. And if you can't locate any of the beneficiaries, you know what you need to do. You need to contact More Private Research, and here are their details.
Are you putting off making your will? Not sure where to start? Don't worry, help is at hand. Making a Will by Remy Ayala is a practical book that takes you on a step-by-step journey through the whole process. Learn how to provide for your loved ones and leave them a lasting legacy. Get it now at amazon.co.uk.
My guest expert, Matthew Moore, explained earlier how important it is for the beneficiaries' full addresses to be included in the will. That will make them more findable when the time comes. But what if they move? Do you need to change your will? No, you don't, but you should create an address memorandum to keep with your will. Update it from time to time in case your beneficiaries move or change their names. Otherwise, you risk some of the beneficiaries not being found later on. So that's my tip for this week. Leave an address memorandum with your will and remember to update it when your beneficiaries move or change their names.
Gifts you make in your lifetime will no longer form part of your estate for inheritance tax after how long? The answer is A. 7 years. Hope you got it right.
I'm afraid that's it for this week. Next time, the topic of the week will be trust and their uses, and my guest expert will talk about investments. So be sure to join me again next time for your weekly dose of family wealth wisdom. I'm Remy Ayala, and before you go, remember to subscribe and please share this video widely to help your family and friends with their own wealth planning. See you next time, and thanks for watching.